This is Pod Populi.
Podcast for the people.
Welcome to Business SOS. This is episode number 62 of Business SOS podcast. This is Rich Sierra, president of Florida Small Business Legal Center. We're very excited today. We have a special presentation today. We have a special guest. We have Alay Perkins with us. She is the author of Why Brand Protection Matters, How to Avoid Costly Mistakes, Increase the Value of Your Business. She's also the owner of Perkins Law Brand Protection. Welcome, Alay.
Thank you. So happy to be here with you today.
I'm very excited you're with us today. Let's get right into it. What inspired you to write the book?
Well, I love that question. I was sitting in my office and I had an aha moment. I had just gotten off the telephone with a potential new client. And after I had that call, I said, I wish I could just hit replay on what I just said, because it seems like I'm having the same conversations over and over again. And people, business owners, entrepreneurs, and executives don't know the information that I'm sharing, and it's getting them into a lot of hot water and costly mistakes, and that's what motivated me to write the book for them specifically.
Tell me about your background and also your practice.
Well, my background, are you're talking about my educational background, or?
Let's talk about your practice, the trademark practice. I know what you do, but for the benefit of the audience, we're talking about brand protection. What do you mean about brand protection, and what type of practice do you have to offer that for clients?
Well, brand protection is basically anything that identifies the company as uniquely theirs. So it could be a logo, trademark, slogan, something that's unique that separates a company and distinguishes it from another. Sometimes people refer that's a trademark. Brand protection encompasses trademark law as well.
What is a trademark for the benefit of our listeners today?
It's essentially anything that distinguishes a company and makes the company uniquely theirs. For example, you can have a word trademark, you can have a logo, design trademark, you can have a slogan. There's even some non-traditional trademarks like sound trademarks that there's many that we're very familiar with. Smell trademarks. There's even a hologram trademark. So it's something that is distinguishable. And like when you see that, you go, I know that's the company. For example, when we see the Nike swoosh, just the swoosh, we know it's Nike.
Yes. I was reading your book, and it's a great refresher for me in intellectual property. As you know, I'm a business lawyer. I deal with a wide variety of different subjects through my career. And sometimes I get into, intellectual property matters. So your book was a great refresher for me to really get up to speed with a lot of new items in intellectual property, especially trademark law. Why is it important for a business owner to, have a registered trademark?
Oh, wow. It is so important because it basically gives them, if they have a registered trademark, and when I say registered trademark, I'm talking about a trademark registered in the United States with the United States Patent and Trademark Office, referred to as the USPTO. It gives them exclusive rights to use that mark so that they can stop other people, copycats, who come along and want to play off of their name. They've got then the teeth to move forward to stop that from happening.
Yeah, I think that's very important. People sometimes confuse copyrights and trademark. Can you, tell us a little bit the distinction between those two?
Absolutely. Well, I've described what a trademark is, and a copyright is any original work of authorship. So sometimes, for example, that's different. So a book, for example, we would copyright the contents of a book. That wouldn't be a trademark. But if you have a business and you've created a logo that is very unique, not only can you potentially protect it through trademark law, you can also protect that logo under copyright law. And there's different rights that apply to each and different benefits for doing that.
Give me an example of the type of rights you get with copyright versus trademark.
Okay, so with copyright, it's not business specific. So if somebody copied your image, no matter who it is, you would have rights to pursue and damages. On the other hand, in trademark law, if somebody copied an image and it was just a logo protected under trademark law, if it was not in your practice area or they were not selling the same types of goods or services that you're selling under your trademark, it could be more problematic to get them to stop using that logo, unless your logo is famous and totally identifiable. So, everything that I say today has exceptions. This area of the law is so nuanced. So it's dependent on the facts and circumstances of each situation.
How difficult or easy is to register a trademark with the USPTO?
Well, for someone that knows what they're doing, it's a pretty straightforward process. But there's lots of details and there's lots of things that can go wrong and do go wrong. Once you file a trademark application, it's not automatic. It's not like you file it and you automatically get a trademark. It's about a 12 to 18 month process to get a registration currently, if everything goes smoothly.
What are some of the obstacles that business owners can face if they try to register a trademark on their own?
Well, one of the things that I see that often occurs is that they didn't do the necessary preliminary searching to see whether they would have rights to that trademark, or by pursuing to get that registration, that they are basically infringing on somebody else's trademark rights. So that's an issue, and there's many others as well.
One of the things that in my practice, and I used to do trademark registrations earlier in my career, then I kind of shifted my focus more towards litigation and contractual matters. So one of the things that happened to me often, which probably happens to you, is that sometimes clients come in and they apply on their own the application simply because it looks like a very easy to fill in the blanks type process when you go to the USPTO website. And then they get that initial refusal. And it could be for likelihood of confusion or just the improper specimen or it was not clear. Talk a little bit more about, the likelihood of confusion issue and some of those common things that happen, that initial refusal, and why is it important for them to hire an intellectual property attorney to, number one, apply for that application, but number two, if they get run into that obstacle, that snag, that they can call you and then to try to fix it?
Well, let me just start out by saying that the statistics say to use a lawyer that has experience in trademark law is you have the best shot at getting a registered mark. Not to say you can't get a registered mark without one, but what can happen is even if you get a registered mark, for example, and you do it on your own, I've had this situation where people call my office and want to enforce their trademark rights. They say, I got a registered trademark on my own. And when I dig a little bit deeper, I realize that it was totally improper that they got that trademark. And then if we would pursue sending a cease and desist letter, for example, that trademark would likely be invalidated.
How can a trademark be invalidated? Just give us a few examples.
Well, if there's a fraud on the trademark, if there's a fraud on the trademark office, if there was somebody else using the mark that preceded in date the company that got the trademark registration and it's causing confusion, providing incorrect information to the trademark office, dates of first use, for example, and also not using the mark. That is a very big thing, because sometimes people think that they can get a trademark and just sit, I've got this great idea, I'm going to get a trademark and sit on it. Well, that's the law doesn't protect that.
Yeah. So, if you don't use the mark, you pretty much can lose the mark.
Correct. In fact, if you don't use the mark for a period of 3 years, it will go abandoned. If there's no intent to use, there's some exceptions to that, but that's generally the law.
You mentioned cease and desist letters. I get calls that somebody received a cease and desist letters. I'm sure you get those calls as well. Give us an example of why somebody might receive a cease and desist letter in the context of a potential trademark infringement and what the business owner should do if they receive such a letter.
Well, what happens is a company starts doing business. They've got this great business name, this great business idea, and they move full steam ahead without checking to see if they're going to infringe on somebody else's rights. And their business is doing great. They're becoming known. And as they're becoming known, the company who had that name and has been operating with that name prior to them finds out about them. And sometimes it even happens in the situation where there's consumer confusion, which is the worst situation, where you've got a consumer that's confusing your business with another business. And that's when someone is very likely and should get a cease and desist letter. Definitely do not ignore a cease and desist letter. The problems just get bigger. At that point, I would highly recommend to anyone listening, go get a trademark attorney, someone that can help you address the cease and desist letter.
I think that's very important. And some of the mistakes that some of the business owners make is that they immediately call the attorney who sent the cease and desist letter and begin to negotiate with that attorney. That's just a bad idea. You're completely outmatched. It's not even worth it.
That is a very, very bad idea, because most people that are not lawyers practicing in this area don't appreciate and understand the nuances, nor are they expected to. But what happens is they'll say certain things that actually hurts their case. When you work with a lawyer, they know how to put it together in such a way that's going to be most beneficial to you and keep you out of hot water as much as possible.
Yeah. And I have a big section in my book, a Business SOS, 8 common legal mistakes business owners make and how to avoid them. And basically, one of the mistakes the business owners make is trying to handle legal matters by themselves. It's just such a bad idea. And trying to save some money, they can create chaos.
100%. As I like to say, penny wise and pound foolish, because, I understand that business owners have tight budgets and they're not always budgeting for legal, but it is something that is just so important and can help a business, grow on a solid foundation and not run into hot water.
Yeah. I want to talk briefly, because you do IP, about patents. Tell me a little bit more about patents, just to have, we talk about trademark, copyrights. I just want to talk a little bit more about patents and what they are, and just give us a little more background on that.
Well, a patent is basically an invention. Like when you hear people invented something new and novel, that falls under patent law. And there's generally 3 types of patents. You've got a design patent, a utility patent, and plant patents. And there's also a provisional patent application that can be filed. That's not technically a patent, but that is something that can be filed to preserve someone's rights.
So someone who has an idea they want to protect, the best thing they have to do is call an IP attorney to advise them whether the idea is patentable, number one, and what steps they have to take in order to protect that idea.
Exactly. And oftentimes it involves a patent search to see what else has been filed previously to determine whether there's viability. But the one thing for listeners to know when it comes to patents that's really important is you need to file a patent application within 1 year of making the idea, the invention, public. If you don't file within 1 year, you lose your rights to do that. And the second important point is the law changed a little over 10 years ago, and now it is first to file a patent application that's entitled to the rights, not first to invent.
I didn't know that.
Well, I'm glad I could fill you in.
Yes, thank you for sharing that with us. Switching back to trademark infringement, which many of our listeners might be involved in that, or at least a lot of my clients. I've been doing this for close to 20 years now. Sometimes clients receive a patent infringement lawsuit just before, without even the cease and desist letter. What does that look like, and what the business owner should do, besides the obvious, when they receive such a lawsuit?
We'll definitely take it seriously and act promptly by contacting and engaging an attorney that can review the matter with you and help determine the path forward. There's strategic reasons sometimes why a lawsuit is filed when we're talking about intellectual property litigation before a demand letter is sent.
Yeah, when somebody receives a lawsuit, I tell them, take a deep breath. You have 20 days, and the lawsuit could come from state or federal law. It could be, either. In some cases, in a trademark infringement litigation, could be in federal court.
It's usually in federal court, and sometimes it could be in state court.
Yeah. So the business owner needs to take that seriously and not ignore it, and because there might be defenses to that type of lawsuit.
100%. And you don't want to waive your defenses by not responding.
Yeah. What I see sometimes people do, they write a letter to the judge. We're laughing because we know that's just a mistake, but it has happened too. They just write a letter explaining everything to the court, and then they send it out. And especially if it's a company has been sued, you cannot do that because you need to have an attorney representing the company, whether it's in state or federal court. And then, when they get that motion to strike pleadings, then that's when they call me.
Okay, right.
So we're like, okay, so what happened? Yeah, I received this lawsuit, and, I've been using this trademark for 10 years. They don't have the right to do that. So I wrote a letter to them. We're like, okay, so what is the letter? So I look at it. So one of the things that I think we both agree is that, if you receive a lawsuit dealing with trademark infringement or any lawsuit whatsoever, but we're talking here in the context of, intellectual property, you do not want to handle that yourself.
100%, 1,000% what you're saying is true.
Because you can do more damage than good by initiating some contact with the court, contact with the attorney. You can end up doing some more damage than it's going to make it more difficult to the attorney to represent you.
Absolutely. I agree with you.
And it'll be more costly because then you have to undo what you did, and you might be actually admitting some things in that letter that your attorney perhaps did not want you to admit in the first place.
Correct.
And that's so in terms of, we're on the same page regarding lawsuits, protection, and the one thing that I saw in your book about common law trademark rights, what is that?
Well, common law trademark rights are basically the rights that a company has when they start using a trademark or a logo or a slogan. There are certain rights afforded to them that would make it more difficult to pursue if there's an issue. But when you have common law trademark rights and somebody comes along and uses the trademark, you still are the senior user. And if they're creating confusion, you still have rights to stop them. It's not as strong a position as having a federal trademark registration, but you certainly do have rights. And when you're using a mark as a trademark, when you're using a mark as a trademark and it's not yet registered, that's when you can use the TM superscript, which is so important.
Yes. I think I have that in my logo. If not, I just need to do that. What if the business owner, say it's a local pizza restaurant, only does business in one geographic area? Do they still need a federal registration, or can they just do a state registration? What can somebody that does not market nationally, what can they do?
Well, yes, if they cannot meet the criteria to obtain a federal registration, which would be the gold standard, so to speak, the ideal, then they can register their trademark with the state of Florida, for example, which certainly does provide them with some trademark rights. Not as vast as a federal trademark registration, but it does put the proverbial stake in the ground for them to claim it as theirs.
I believe this is a simpler process as well.
It is a simpler process. I actually end up doing very few state registrations.
Yeah, I did some of them early in my career as well. And it was just a form you submitted. It's really more ministerial. They don't check,
Yes.
and they go ahead and approve it. Sometimes, people have fictitious names, and they believe that it's a trademark. Can you tell us a little bit more about that fictitious name? I don't believe it's a trademark, so it could be, but people feel comfortable using a fictitious name, and they said that's my brand. So tell us more about that.
Well, it's possible that a fictitious name becomes their a brand. For example, the name of my law firm is Perkins Law Brand Protection, but that's a DBA. That's a fictitious name. The entity is L.A. Perkins Law Firm, PLLC, which I operate under Perkins Law Brand Protection. And that is protected. I have my logo protected, and Perkins Law Brand Protection is part of my logo. So it can, depending on how it's used, qualify as a registrable trademark.
Yes, and I believe the purpose of a fictitious name when you register in Florida is for them to know who is behind that particular fictitious name, who's the owner of that name. So that's you basically disclose who the corporate entity is utilizing that fictitious name. Like mine is Florida Small Business Legal Center. That is my brand, but that's actually a fictitious name, which also is my mark. But the corporate entity is Richard Sierra and Associates PA. So it's just an example. Some people believe just registering a fictitious name, that's sufficient. That's not. It's simply notifying the public who you are behind that name.
Correct. And when you file a federal trademark application, you have to say who the owner of the mark is, and that's when you would put in your legal entity name.
That's correct. Yeah, we have a few minutes for this segment. Tell me more about your practice, the type of services that you offer.
Well, I help business owners from small business owners that are just getting started to established businesses identify their brand assets. So a lot of times people don't realize what they have and what needs protecting. And we talked about 3 types of intellectual property. There's also trade secrets. So we've got trademarks, copyrights, patents, and trade secrets. And so I help them identify and then come up with a plan and a strategy to protect those brand assets. And depending on budget, depends on how that strategy is going to unfold, then proceed with making sure we protect the assets. And I also help clients monitor the market to make sure that no one else is using their trademarks, and then send cease and desist letters. Of course, I represent people in responding to cease and desist letters, and when necessary, filing a lawsuit or responding to one.
Okay. So you're very busy. What is the name of your practice?
The
name of your law firm?
Perkins Law Brand Protection.
Okay. And what is your website?
www.brandprotection.law.
And what is the best way that people can reach you?
Well, the office phone number is 561-467-4001, and they can also send an email to contact@brandprotection.law.
Okay. Do you have more minutes to stay for the next segment?
Absolutely. Absolutely.
Right. Okay, so thank you very much, Leigh, for being here with us. This is, again, it's episode 62. We will have more conversations with LA for the next segment. And this one we're going to do a deep dive. We're going to talk about specific mistakes business owners make in terms of protecting their intellectual property or not protecting it. So we're going to talk more about that right from her book. Her book is Why Brand Protection Matters, How to Avoid Costly Mistakes and Increase the Value of Your Business. It is available on Amazon, Barnes & Noble. You can ask for your local bookstores as well. So I close the show. If you're interested in reaching me, my email is rich@richsierra.com. My website, if you're interested in my legal services, is floridasmallbusinesslegalcenter.com. We're on Facebook at FSB Legal. You can always call me at 866-842-5202. If you like the podcast, please follow us and give us a good review and share it with your friends. Again, until next week, this is Rich Sierra. Remember my goal is to help you succeed.